you. All right. So good afternoon, everyone. Thank you for joining us at Secular AZ today. We are a 501c3 organization focused on protecting the Constitution and the separation of church and state for over a decade. We have great programming, including we just wrapped up a series of school board candidate forums that have been going on Wednesdays at 6. We are switching gears on Wednesdays to start hosting some candidate forums for our statewide candidates and for the special election happening in Maricopa County for the county attorney's race. So next week, we've sent out the invitations to both county attorney candidates. I believe we've heard back from one, so stay tuned, and we will be discussing the role of the county attorney. Next Friday, we also have these speaker series on Fridays at noon. Next Friday, we're still working on it, so it's to be determined. But I hope that you all take a look at our events page and sign up for those different events. Thanks, Lindsay, for putting it up there. We also have t-shirts for sale that say I read banned books. So if you want one, all proceeds go to us so we can put together this kind of programming. We also have created a space on our website to showcase secular wedding and funeral officiants. So if you are certified to officiate weddings, please reach out at info@secularaz with your bio and a picture. And finally, we have a fundraising opportunity with the donation matching campaign right now, put up by a generous and loyal supporter of Secular AZ. So I hope that you will take some time today to support our endeavors. We are the only organization doing this kind of work in Arizona. Today, I'm very excited to be speaking with Laura, and I want to make sure I get your name right. Is it Portuondo? Is that how you say your name, Laura?
Portuondo.
Portuondo. Thank you for the correction. I should have done that before we even started this webinar. Laura is a fellow with the Program for the Study of Reproductive Justice at Yale Law School. Her scholarship addresses the intersection of the First and 14th Amendments, of First and 14th Amendment rights. Prior to her current position, Laura clerked for the Honorable Robert A. Katzman of the U.S. Court of Appeals for the Second Circuit and the Honorable Jed S. Rakoff, and I hope I'm saying his name right as well, of the U.S. District Court for the Southern District of New York. Before her clerkships, Laura worked as a Judicial Strategy Fellow at the Center for Reproductive Rights, and she holds a JD from Yale Law School and a BA summa cum laude from Yale College. So welcome, Laura. Thank you so much for taking time out of your busy schedule to join us today. I know our members are looking forward to it. So if I missed anything in the bio, please fill in the gaps. And without any further ado, just go ahead and show us what you're going to show us.
Great. Thank you so much for the introduction. Hi, everyone. I'm glad you were able to make it today. That pretty much covered my bio. Right now, I'm doing a lot of scholarly work, sort of more in an academic trajectory. And I'm today going to talk a little bit about some of the work I'm doing, but also hopefully give a pretty easy introduction to some constitutional law theory that might be interesting and helpful to you all when thinking about how we mediate between First Amendment rights. So the First Amendment, that's the amendment that covers freedom of religion and also the Establishment Clause. So all things religion are under that First Amendment. And then the 14th Amendment covers all kinds of things. But one of the big things it has is the Equal Protection Clause. So that's protecting against things like race discrimination, sex discrimination, all other kinds of discrimination, and also covers substantive due process, which is a fancy term for the rights to contraception, the rights to abortion, things like that. So hopefully I can start with a little overview of how we think about rights in those two contexts, and then I'll shift to describe a paper that I've recently authored to give you a kind of a concrete example of how we mediate conflicts between these rights. So basically, when we're talking about individual rights under the Constitution, a lot of the time we're thinking about people coming to court, often the Supreme Court, though there's a lot of courts other than that, with a claim saying that a law that the state has passed is harming you in some way. It could harm you in all kinds of different ways, saying, you know, this is limiting my freedom of religion, this is discriminating against me, all the kinds of things that you see coming up to the Supreme Court. And generally, when we're thinking about rights under the First Amendment, remember that's the religion clause. And when we're thinking about rights under the 14th Amendment, that's sort of the discrimination and abortion clause. There's two big buckets of rights. So the first bucket of right would be a liberty-based right. That's probably going to be most familiar to everybody from the religion context. So a liberty right is basically a right to engage in certain kinds of conduct free from government interference. So if you're thinking about a liberty right, you're thinking about a right to, say, go to church without the state saying you can't do that, or a right to engage in all kinds of religious conduct without the state preventing you from doing that. If we're thinking about it in the context of the 14th Amendment, the abortion right is a really quintessential example of that. So you have a liberty interest, you have a freedom to go get an abortion, you have a freedom to go get contraception. And when the court overturned Roe, it overturned that liberty right to abortion. So that's one bucket of rights. The other bucket of rights that you can get is called equality rights. And that might feel a little bit more familiar, particularly to the 14th Amendment context. And under the umbrella of equality rights, the idea is not that you have any specific conduct or thing that the state can't interfere with you doing. The idea is that the state can't treat people differently when they're doing similar kinds of conduct. So it wouldn't be a right to say, go to church, but it would be a right to say, the state can't stop you from going to church if it's letting other people do other similar things. So it's a discrimination right. And if you think about abortion as a discrimination right, you could say what's going on here is not that you just have some abstract interest in getting an abortion. Your interest instead is an equality one. And the problem is that the state is allowing certain groups of people, often cisgender men, reproductive freedom, but it's not allowing other people, such as cisgender women or trans or gender nonconforming people, the same rights. So that's a discrimination right. So we have these two big buckets of rights, but it's actually a lot more complicated than that. Because, as you might imagine, there's all different definitions of what a liberty right might mean, as well as what an equality right might mean. So when you're thinking about liberty, the most obvious kind of liberty right is the state can't say, pass a law saying you can't go to church, right? But what about if the state says something like, we're going to fund all schools, but we're not going to give funding to religious institutions? Well, the state isn't saying you can't have a religious school, but the state's also not giving you funding in the way that it's funding other places. So there might be some question about whether your liberty interest really includes that interest in engaging in getting fundings in a non-discriminatory way. And this is really obvious, again, from the abortion context, when we're thinking about things like the Hyde Amendment, which says you cannot have funding, federal funding, for abortion. So people who are on Medicaid, who are very poor and might need to get an abortion, aren't getting the money for their abortions, which often means they cannot access the right to abortion at all. So you can see there how a broader theory of liberty is necessary for most people to be exercising those liberty-based interests. And then in terms of equality, you can also have all different kinds of definitions of equality. Perhaps the simplest theory of equality that's going to be the most familiar to everybody here is one that says it's called an anti-classification theory. And that means that you just can't specifically target a group with a law. So, you can't have a law that says no Jewish people shall apply to this job, right? Or you can't have a law that says no women shall apply to this job, right? That's the really easy, basic kind of discrimination right, or equality right. Another kind of understanding this right could be a discriminatory purpose. So the state can pass all kinds of laws, but it can't do so when it's motivated by a bad purpose. It is trying to harm a particular group. And then, there could be an even more expansive theory of equality, which is to say that the state has to affirmatively take the differences of different people into consideration when passing laws. So I'll go sort of through each of these with the example of abortion, because I think it's really easy and helps illuminate the stakes of these different theories. So when you come to an anti-classification theory, we might say that abortion does not implicate the sex equality rights of women because abortion laws don't specifically mention women. So that anti-classification theory doesn't work for abortion. So thinking about purpose, well, people who passed laws prohibiting abortion, did they pass those laws because they wanted to harm women or they weren't thinking about the interests of women? So did they have a discriminatory purpose? Courts have often said no, but you could see how you could make an argument that these laws do have a discriminatory purpose. And then finally, if you're thinking about that substantive equality theory that says you need to consider the interests of particular groups, it becomes really clear that an abortion regulation does in fact violate women's equality because the state is not considering the unique reproductive needs of women or trans and gender nonconforming people. So that's a big overview of these different buckets of sort of liberty and equality. I know it's a little complicated, but constitutional law is a little complicated. But the work that I do specifically is thinking about how courts, and specifically the Supreme Court, is thinking differently about what liberty and what equality means in the different contexts of religion and thinking about race or sex equality or liberty-based rights. As you may have noticed, the Supreme Court seems to very frequently rule in favor of religious litigants and almost never rule in favor of those bringing race or sex discrimination claims. And the court has in fact gotten rid of that liberty interest in obtaining an abortion. Well, I think that's because the court is applying different theories of equality and different theories of liberty in those two different contexts. In the first context, the court has very expansive understandings of liberty and equality and very limited understandings in the other context of gender-related liberty or equality. And so with that overview and broad understanding of what I'm working on, I want to give you all an overview of a paper that I have recently written, and that's going to be coming out in a law journal pretty soon, which hopefully might make these sort of two competing views of liberty and equality more apparent, and how the court make clear how the court is being very inconsistent in how it's understanding what liberty and equality means when it comes to the right of religious people and when it comes to the rights of women and racial minorities. So the paper that I've written, it's entitled Affecting Free Exercise and Equal Protection. And in that paper, I identify a growing discrepancy in the court's approach to equality jurisprudence across its free exercise, that religious discrimination, First Amendment, and its 14th Amendment, race and sex discrimination jurisprudence. And that discrepancy has to do with the role of a law's effects under both of these two doctrines. So for a very long time, the Supreme Court has said that a law's effects on a particular religious group, sex group, or a racial group are not particularly relevant to determining whether those laws are discriminatory. So this is the reason why it's so hard to bring a sex discrimination claim against a lot of reproductive rights regulations. Because even though we all know, you and me know, that these laws are having a really severe disparate effect on women in particular, for some reason, nobody can make the argument that this is discriminatory on the basis of sex. So it's that unwillingness to consider effects. And so while this rule has been longstanding for almost 40 years that effects don't really matter in either context, the Supreme Court has essentially eliminated this requirement in the religious discrimination context alone in the past 5 years. In that context, the court has explained that a law's effects on a particular religious group or religious plaintiff should play an increasingly important and even dispositive role in finding that a law is discriminatory. And so what I do in this paper is I say that, yes, the court has done this. And in doing so, it's made a really powerful case that we should be considering effects in the race and the sex discrimination context too. That is, if effects matter under the Free Exercise Clause, they should matter too under the Equal Protection Clause. And so I'll sort of set out that case briefly for you all here. I'm going to start with the history of free exercise. That is, free exercise, that's that religious discrimination jurisprudence. And equal protection jurisprudence, that's that race and discrimination jurisprudence. And I'll show how, as a historical matter, these two doctrines of discrimination developed in tandem and developed very similarly. Then I'll very briefly explain how the court has thrown out its rule against considering effects in the free exercise context in recent years. And then finally, I'll put together that history with that recent development to show how recent free exercise doctrine has made such a powerful case that we need to have a broader consideration of equality in the equal protection context too. So as an initial matter, I want to define a term that I'm going to use a lot in this presentation, which is a term called a triggering rule. So a triggering rule is the threshold showing required to demonstrate that a law burdens a right. What that means, a triggering rule basically says, when do we know that a law might be discriminatory? And effects are really relevant to determining that. So as a historical matter, in both the religious discrimination and the race and sex discrimination context, the Supreme Court was willing to say, yes, like effects are relevant to determining whether a law is discriminatory. That, however, began to change in about the mid-1970s in a couple of cases. And in those cases, the Supreme Court said, actually, a law's effects alone should never really indicate that a law is discriminatory. They couldn't do it. And the reason that the court said this was basically, if we allow effects alone to show that a law is discriminatory, essentially, we're going to be invalidating every law, and everyone's always going to win on their religion and sex or race discrimination claims. So it would just require the court to strike down too many laws, and so the court rejected it. This began to change. This, however, despite this rejection of the role for effects in these two cases, the court later sort of backtracked a little bit, saying, well, actually, effects might still be relevant in a couple of ways. First, effects might show discrimination by being important evidence that laws were based on a discriminatory purpose. Remember, I talked about that purpose-based definition before. So laws might show that, effects might show that a government passed a law because it had a discriminatory purpose against a religious, race, or sex group. And additionally, in addition to being evidence of a discriminatory purpose, effects might still, in really extreme circumstances, such as where a law is impacting almost only women, almost only a racial minority, they could still trigger heightened review. Ultimately, however, and this has been the rule until very recently in both contexts, the court said, no, effects should not be playing a meaningful role in showing that a law was discriminatory, and it did so by defining a discriminatory purpose in a very narrow way. So the court said, first, a discriminatory purpose is going to exist only where lawmakers essentially pass the law because they specifically wanted to harm a protected group. They did it because they did not like the group in question and wanted to discriminate against them. So as you can imagine, that's a really heightened purpose requirement, and most laws aren't passed with that kind of a discriminatory mindset in mind. And also, the court said that there's also not really any residual leftover standalone role for effects. Effects alone are going to trigger heightened review only if a law is affecting exclusively members of a protected class. So despite this turn away from effects over the past 40 years, in the past 5 years or so, the Supreme Court has revived the relevance of effects in the free exercise religious discrimination context alone. and has allowed evidence of a law's effects on particular religious groups to serve as really compelling evidence that a law is discriminatory. So this really began about 5 years ago, but the main takeaway here is that the court departed from that really stringent definition of purpose that it set out in its previous case law. And so what the court did is it said a law is not discriminatory on the basis of religion only where a law is based on a desire to harm religious people or harm a religious group. A discriminatory purpose exists also where a law is based on something called selective sympathy or indifference, which is a fancy word for saying a law is based on unconscious bias. So that is a much broader definition of purpose and one that a ton of laws are going to satisfy. Remember how I was talking about abortion regulations before? Well, even if abortion regulations aren't passed because lawmakers don't like women or don't like gender nonconforming people who might be impacted by the laws, they might have bias against those groups, and that might be the reason they're passing the law. So you can see that if you have this definition of purpose, you're going to be capturing a lot more laws. And in addition to expanding this purpose rule, the court explained that effects alone could trigger heightened scrutiny and could show that a law was discriminatory if they're just under-inclusive. So if the law is not applying to some people who you would think it would apply to, and most laws really are under-inclusive, so that's a really broad new definition of discrimination. So the takeaway here is basically that the court has embraced a really broad new theory of discrimination in the free exercise context, but has not done the same in the equal protection context. And so what I ultimately do in my paper is to argue that this is unfair and this is inconsistent. That's because the justification that the court has given for shifting to this new definition of purpose and this new standalone triggering rule, the justification applies just as well when you're thinking about race or sex discrimination claims. As I said before, a lot of laws are premised not based on a desire to harm a particular racial group or a desire to harm a particular gender group. They're passed because lawmakers either don't care about the group that's affected, or they're just not really aware of their interests, right? So they're based on unconscious bias. And that theory of discrimination makes a ton of sense when it comes to race and sex discrimination too, because we know that people generally don't exhibit their racism or their sexism in that kind of overt way. Instead, it's based on those unconscious biases. So I argue in the paper that we should be applying this newly broadened theory of equality in the race and sex discrimination context too. And I show why the justification that the court has thus far provided for not doing so is completely inadequate. So that's a pretty quick overview of the paper that I've done. This is the non-legal audience, I think, so I don't want to get too deeply into the weeds here. But that's the way the paper goes. And, future projects that I'm interested in considering would be things about how the court has adopted a broader theory of liberty in the free exercise context than in the race or sex context.
We do have some questions, and the first one actually does come from a lawyer, volunteer on our legal team, and this comes from Beth. Beth is asking, what about privacy rights? So what about privacy rights? Where do they fit in this scheme? And I thought the court took away federal privacy right, not liberty right to abortion.
Yeah, that's a great question. So Roe versus Wade was actually premised sort of both on a privacy right and a liberty right. It's a little bit confusing what the court was relying on there, but there's actually an overlap here, which is that privacy rights are a form of liberty right, which is to say privacy is your right to engage in certain kinds of conduct without government interference, right? That's basically a liberty right. And so your question there, I think goes to other things I'm interested in working on, which is how there's a broader theory of liberty when it comes to religion than when it comes to the rights of women or gender minorities.
We also have another question from anonymous attendee, and they are asking, I think it's supposed to be, could you discuss the clash of free exercise and equal protection, such as religious right to discriminate against gays?
Yeah, that's a great question too. And I think that's one of the implications of this kind of work. I think the questioner here is thinking about laws that are, say, anti-discrimination laws, and say you can't discriminate in, say, selling goods to same-sex couples. And somebody who's selling a good says, well, it violates my religious liberty to have to give out these goods to people. So that's a real clear conflict between sort of that liberty right of the religious person and the equality right of the gay person, right? And so I think one reason why it matters so much that the court has developed different conceptions of what liberty and equality means in these two different contexts is that when you get that religious liberty or that religious equality right, it's a super, super broad right. And basically anyone doing anything to a religious person that they don't like counts as discrimination or counts as a violation of their rights. But then when you look to the rights of, say, queer people or gay people, the rights definition is super, super narrow. So you get a conflict of this huge, hefty religious right with this very tiny, narrow conception of what a right to sex equality is, or a right to, marriage, something along those lines. And so the religious right wins every single time.
We have a few more questions coming in. Deborah Burdett is here, and she has the question, which amendment was the Citizens United decision based on?
So that, I believe, was a First Amendment case. That was a freedom of speech case, but it's a really good question because this same idea of expanded liberties and expanded equalities, that's also happening in the speech context. And there's actually a case that's going to the Supreme Court right now. It's called 303 Creative, that might interest some here, which is about that conflict of the rights of religious people and the rights of queer people. And it's framed as a free speech case. So you can actually get these kinds of claims under a speech claim as well. So it's a good parallel.
Deborah also asks, was this, I think she meant to say, what was the decision that gave corporations the rights of people? Or
I think she's probably thinking of, oh my gosh, I am blanking right now, but it was a contraception decision. It'll come to me. So Hobby Lobby, thank you. Hobby Lobby versus Burwell. That's the Supreme Court decision. And that said, it applied a statutory religious protection, but it's a similar idea to the constitutional religious protection. But it said that corporations have the same religious liberty rights as human people. And so that means the stakes of this, what's the scope of liberty, is even more important because now we are applying this broadened rights framework to corporations as well as human people.
Great, thank you. And Diane Post, who's the head of our legal team, as well as a board member, she asks, could you discuss the magnification of the exercise right and diminishment of the establishment right in the First Amendment?
Yeah, that's also another good question. So for those who might not be familiar, the First Amendment has both a free exercise clause and an establishment clause. The free exercise clause is a religious liberty right. Individuals have it. They have a right to engage in their religious practice. And then there's the establishment right, which is sort of a counterweight to that, which says that the state essentially may not, there's different interpretations of it, but the state shall not establish religion in any way, whatever your interpretation of what that is means. And so what the court has done in order to have this increasingly expanding free exercise right is to say that this establishment clause right is extremely, extremely narrow. Because if we're thinking about, say, religious liberty right, this comes back to sort of the funding case that I was talking about before, right? One conception of liberty might be, well, the state can't stop you from doing something, but it doesn't have to fund you in doing that either, right? And so historically, the free exercise clause said, well, you can't stop people from having religious schools, but you don't have to fund them either. And that's good because of the establishment clause. We don't want the state involved in establishing religious schools, right? Or funding religious schools. And the way that you expand that liberty right to say, no, it's not just that the state can't stop you from doing things. You have a right to funding too. Well, what about the establishment clause? The only way to make that newly broadened conception of liberty work is to say this establishment clause is very narrow and in fact does not prevent that kind of state funding to make room for that really big liberty right.
Well, and here in Arizona, the party leadership, the majority party in the state legislature just put forward a massive voucher expansion and opened it up to anybody, including people who were already sending their kids to private schools. In fact, I read somewhere that it's 75% of the people who are taking advantage of this $7,000 taken from public schools and put into oftentimes religious private schools. It's open to anybody. And 75% of them were already, there's no record of them in public schools. So they already had their kids in private schools or were homeschooling them. It also means, a mother of 6 can now, $7,000 per child, keep her kids at home and teach them anything that she wants to, so.
Yeah, and I think it's a really important point to think about too, because, while you can sort of see the discrimination argument, you understand what they're saying, right? You're funding secular schools, you're not funding religious schools, that's not fair, right? There are arguments against that, and I think you just articulated some of them, but actually it's discriminating among religions too, because what it's doing is it says schools like Catholic schools that have the infrastructure to set up schools, big, common, popular religions in the US have the ability to take advantage of this kind of benefit when smaller religions, minority religions, practiced by immigrants and things like that, they can't take advantage of that funding.
This one comes from, and I hope I'm saying your name right, Farrell. Is there a direct practical application of what you've addressed in your paper?
It's a good question. I'm an academic, so it's very fair. Yeah, so I think the practical application here is to say, when people are trying to bring claims for a race discrimination plaintiff or a sex discrimination plaintiff, somebody who's been discriminated against, you could try to bring these kinds of theories that I'm articulating here. Courts might not accept them right now, but the hope is that in the long term, they might do so. And actually one way to do so is through state courts, which might not be quite as packed with conservative judges as a federal court. And I think it also helps, I guess part of the reason that I'm doing this to highlight this inconsistency is in fact to say, look, this is not legitimate what courts are doing here. This is not because of real differences among these rights. It's just because the court's being essentially inconsistent, and what it's doing is it's favoring the rights of powerful, wealthy people over the rights of poorer or less politically popular minority groups. And when you see that, and when you understand that, and when you have evidence of that, which is what I'm trying to provide here, that gives you fodder for something like court reform or something along those lines.
Well, and sadly here in Arizona, our Supreme Court is definitely packed, definitely packed. So we come up against that all the time. Diane has what is more of a comment here. I think it's in reference to the other question about corporate personhood, because, you mentioned Hobby Lobby. And so I think she's just giving some background clarification. Corporations were said to be persons back in the 1800s, but that changed by 1889 when in Minneapolis versus St. Louis Railroad and Beckwith, the court ruled that corporations are persons for purposes of application of the equal protection and due process clauses of the 14th Amendment. That was followed by Lewis A. Liggett and Co. v. Lee, finding that the equal protection and due process clauses of the 14th mean that chain stores cannot be taxed differently, and Wheeling Steel Corp. Versus Glander, that corporations have the same rights as natural persons under the equal protection clause of the 14th Amendment. So that's her comment. If you want to expand on that, by all means. Yeah.
And I just want to add that there's some ambiguity about like which rights would be included in that. Like there was ambiguity in up to the leading up to the Hobby Lobby case that I was talking about. Well, sure, corporations have the right of persons, but do they really have religious rights? I mean, that seems totally incompatible with what corporations are, right? They're not people. People are the ones with the consciences who have these religious beliefs. And so that Hobby Lobby case said, no, corporations are people, are people, are people. They have these free exercise rights too.
And we do have another question coming from Alex. And again, if anybody else has any questions, by all means, put them into the Q&A. Alex says, when considering bodily autonomy with respect to discrimination, would Thompson's violinist analogy act as a catalyst to demonstrate the standing of persons claiming harm? Essentially, those who cannot become pregnant have more bodily autonomy than those that can become pregnant, thus discrimination.
Yeah, I mean, that's why sort of using an effects-based framework is really helpful, right? Because if you're looking at purpose, and specifically when you have purpose listed as like hatred, basically, like the violinist example. So the violinist example is like, oh, well, for those who are not familiar, if, pregnancy is sort of like if there's a tiny violinist who is going to die and the only person who can save him is a person who's matched his blood type and it's a specific person. The state would never compel you to, hook up a bloodline to this tiny violinist for 9 months. So why does the state require you to carry a pregnancy to term for 9 months? Same idea. So when you're using a purpose-based framework, that example doesn't really give you anything, right? Because even if state lawmakers wouldn't have required this of anybody else, they still didn't do it because they hate women, or they would certainly say that, right? So that's why when you get to the question of effects, it's so much more helpful, because you're like, well, look at the impact this is having. There's whole groups of people in this world who you are not subjecting to burdens in order to protect potential life. You won't raise taxes so that you can fund Medicaid, so that you can fund prenatal care, so that you can fund, better SNAP benefits, so that people who actually want to have children can have those children in a safe environment. Instead, the only way that you're actually protecting potential life is by requiring the specific targeted burden of personal autonomy on women and gender nonconforming people, and those people alone.
And yeah, there was, and perhaps Diane can maybe elaborate in the Q&A too, but I believe that there was an injunction, I think, with the Attorney General. And, I was in a meeting where they were kind of debriefing about that, that day in court. And essentially the takeaway that I got from it, hearing, their reporting on it, was that, well, the fetus, the embryo, is more important than the mother in absolutely every case. So that's not really all that inspiring. Right. And then Diane again is asking, can you discuss the problem of a comparator and discrimination cases, and that the difficulty when the situation only applies to women, e.g. pregnancy and childbirth under the Duke standard?
Yeah, that is a tough question, comparators in equality law in general. Because equality law, the basic idea is you treat similarly situated people the same, people who are the same. And it's really easy based on, I think, stereotypes about women, I think in particular, to say, well, actually, there's something unique and biological and that's different about women than other people. And that's why they're regulated, right? Only women, which we know is not true, but only women can get pregnant. And so that's why they are the ones who are bearing this burden, right? So I think the way to push back on that is you don't look at comparators in terms of just sort of like, oh, the way that men and women are, right? You look at comparators in terms of what is the state's purported interest? Why does the state say that it's regulating this, right? And so when it comes to abortion, the state says we're doing it to protect potential life, right? We're doing it because we care about the sanctity of life. And then when you get to that level, you start to see that there's all kinds of people who could be contributing to this project of protecting potential life who aren't. And that's sort of what I mentioned before. The state is not raising taxes on people to try to provide services for people who are pregnant. It's not trying to ensure better outcomes for children in foster care or other kinds of things. So when you zoom out to the level of what is the state actually saying it's doing, and you sort of get away from the sort of, oh, well, it's just biological thing, you see that there are, in fact, comparators, and that the state's really just not taking its interests seriously when it comes to anybody but women or gender nonconforming people who could get pregnant.
Well, we do not have any questions on the Q&A or on the Facebook. I really learned a lot today, and I'm so grateful for you joining us today. And I know that that everybody else enjoyed it too. Just it was very rich discussion with the questions that came from the audience. So thank you for all the questions, and thank you for the work that you do, Laura. What's next for you? I'm just curious,
Well, so I'm actually applying for tenure track professor positions right now. So we'll see how that goes, but I plan to keep writing about these issues because I care about them a lot and I think they're really important.
Good. I'm grateful that you do, and I'm sure we're all grateful. Oh, wait, one more. Let's see. Okay, we got one more. Can you compare 303 Creative with Masterpiece Cake?
Yeah, so they're basically the same case. So Masterpiece Cake Shop was a religious cake baker who did not want to make a wedding cake for a same-sex couple. And the court basically punted the question, and in doing so created a very broad theory of religious discrimination, but it's complicated, so I won't get into it. In the 303 Creative case, the court has taken up the question again because it didn't really deal with it the first time. And this case, it is a website designer who designs wedding websites, and they do not want to make a wedding website for same-sex couple. And the couple is arguing that this violates a state law that prohibits discrimination on the basis of sexual orientation. So here we have that conflict between the right of the religious person who's claiming a religious liberty right, and the right of the same-sex couple who's claiming an anti-discrimination equality right. But what's really interesting about this case is that this brings us back to that speech question, which somebody brought up before. What the court is doing is it's taking it under a free speech lens. So it's violating the rights of the religious person to not speak, to not say things that conflict with their personal beliefs. But as you might imagine, this is just a repackaging of the religious liberty claim, because it's either my religious liberty, I don't want to do this because I have a religious belief against it, and so that violates my religious liberty rights, or I don't want to do this because it violates my religious beliefs and that violates my free speech rights. It's the same kind of claim, basically.
I have one question. I'm curious as to, with some of the cases that we know that are going to be coming before the Supreme Court in their next session, is there one that gives you particular concern or that you're tracking very closely?
I mean, I think the 303 creative case is one, because right now the law holds that if a anti-discrimination law, that basically anti-discrimination law is okay. It's advancing compelling interests in protecting people from all kinds of discrimination, whether that's sex discrimination, sexual orientation discrimination, race discrimination, whatever kind of discrimination you can imagine. And courts have in the past said, well, if that conflicts with your religious beliefs, that's sort of too bad, because the law wasn't passed with a purpose of harming religious people, right? And it doesn't specifically target religious people, right? So what happens here is that the court is saying an incidental burden on your religious beliefs. So the state didn't pass this law because they wanted to discriminate or they wanted to make you say something you didn't want to. They passed it because they wanted to protect the dignity and equality of groups of people. And the court, I am almost certain, is going to rule in favor of the website designer and say that actually, if you have a belief against complying with anti-discrimination law, you don't have to comply with it. And what that means is it essentially guts discrimination requirements, because not the only people, but many of the people who do not want to comply with discrimination laws are people who have conscientious objections to doing so.
Well,
cheery.
I know. I'm like, okay, no, like, hope everybody has a great weekend. Oh, look, there's one more in the Q&A. Let's see what we've got now. Okay, Diane again says, how does the 303 Masterpiece case violate the Heart of Atlanta motel case from the civil rights cases that said your religious beliefs against Blacks and whites mixing?
Yeah, so I mean, I think that's a tough case for the court to deal with, right? I mean, this is a foundational principle of American law, which is to say that these anti-discrimination laws are okay. They were passed, in the wake of the 14th Amendment. They're really important to a functioning society, a pluralistic society. And I think the way the court gets around it is they'll just say, well, this is just limited to speech specifically, right? This is just somebody who is designing wedding websites which have words on them. And so those words are speech. And so what we're saying is when it comes to speech, you don't have to comply with the right? So you could still see, you still have to let somebody come to a hotel, right? You can't discriminate against the same-sex couple coming to a hotel. But the reason that I'm not optimistic about that distinction is that anything can be speech. And the court is becoming more and more broad about what speech means. You can say, yes, me having somebody in my hotel, that is expressive. I think it's saying to the world around me, to other guests at my hotel, that I have respect for same-sex couples, and I don't. So it's a very slippery slope, and this is just the wedge in the door.
Yeah, again, it's kind of spoiling my weekend a little bit here. But again, oh, now we've got more, and I do have to stop at 1 o'clock. So let's see. I'm happy with all the engagement, but I do have to stop at 1. What will happen when this is from Beth again. What will happen when restaurant owners refuse to serve Blacks again based on religious white supremacy?
Yeah,
I think that's a more rhetorical question.
Yeah.
And then another comment from Diane, like, yeah, we're going so far backwards. She says, I can put a sign in my hotel saying no Blacks, no gays. Yeah, it's we are living in some really strange times. I did not think that in 2022, this country would be so driven by religious extremists, the Christian Taliban. That's essentially what they are. And it leaves all of us in very vulnerable places. And so I guess one takeaway we have here is that, our elections matter very, very much. I hope that everybody, and I know that the people on this call are paying attention, all the way down to their school board races, their ballot initiatives and everything else. But perhaps it's the time for all of us that maybe want to stay in our comfort zone to step outside and to, gather signatures for those ballot initiatives, or knock doors or make phone calls for a candidate that you really believe in, again, all the way down to your school board level, because, this legislative session too, we saw our state legislature do as much as they could, not only to expand, these, religious exemptions and things like that. That was a big problem this session, but also to cut municipalities and school boards and, counties, government agencies, whatever, to cut them off preemptively from being able to put forward any kind of non-discrimination clauses, or, to, set their own minimum wage, or to, we had a small town in Arizona a few years back that wanted to have a plastic bag ban. And so things like that, while those school board races are incredibly important, and sometimes the only way that folks can combat in their own communities what's happening at the state level by the majority party, those things could go away. And so it's just really important for all of us to get involved. So that's my 2 cents. And if you are free this weekend because of all this depressing news, you should find one of those candidates or initiatives to get on board with. And then I just want to say thanks again, Laura. It was my pleasure, and I know everybody else really enjoyed it. So thank you so much for taking time. I hope you are able to have a nice weekend this weekend, despite all of the information you've given us as well.
Yeah, thanks so much. And I just want to echo what you said. I'm really happy that there's people here engaged and interested, and power is with the people. So I think it's great to be involved with this.
No, absolutely. All right, everybody, have a wonderful weekend. Go to secularaz.org if you want to see what we have coming up next. And thanks again to everyone for showing up, and have a great weekend and stay safe. Bye-bye.